Good morning, good evening, good afternoon. My my wife has a what do they call that? An espresso. Get these little pods and it punctures them and spits out. I think it's espresso. I don't know. It's pretty tasty. Anyway, this is on Worden. Good old Earl David Worden. The state asked for yet another extension of time. Their excuse was that they had been helping other people with their cases, and so they couldn't focus on this appeal. So they were given until February 7th, 2024 to file their brief. And this was their third extension, and so no further extensions will be granted absent exceptional circumstances. So it's weird. I haven't looked into it, so who knows? Maybe I'm just dumb and naive as to Texas. All right, Dozy, you go and doze. Texas might do something a little different than what I'm used to, but it looks like they just have the clerk of the court grant these things. So interesting. I guess they must have like three specific extensions. Locusts, is there something going on, or are you hearing a dog snore or what? There's washing machines going off. I've got a fish tank behind me, and I've got a dog snoring, so I don't know what you're hearing. 80 degrees Fahrenheit. Oh, must be nice. So anyway, that's what's going on. Earl's rotting in prison while the state is dragging its feet. And again, I am definitely not a fan of Earl. I am one of the least fans of Earl. If every fan of Earl was put on a scale, I am the guy who, if he shows up at my house, I have said I will absolutely 100% open fire, and I will not stop firing until he is no longer a threat. So there is zero love lost between me and Earl David Worden. But justice is justice and fair is fair, and he's getting a raw deal. I mean, if he did it, then the state should move ahead and get this process over with so that the doubt could be removed. Anyway, moving on. In Decastro's Las Vegas case, he now is represented by Michael Mee. I have no reason to suspect Michael Mee is anything but a competent attorney. So what does that mean? Well, what it means is, number one, Decastro has realized that he can't do it and he needs an attorney. So there you go. You will be accused of being a R supporter if you expect the judicial system to be fair. I don't support R. Sadly, our justice system is the only justice system we have. If we remove the justice system, the next step is just vigilantism, and that is just that's essentially just survival of the fittest. The strong will rule the weak. That's not really a good system to operate on. Yes, he definitely learned the hard way. He is not an attorney. Did he hire Mr. Mee privately? Well, yes, because this Michael Mee is representing the plaintiff, Jose Maria Decastro. So this is in the civil suit. Now, so it means, number one, that Decastro realizes that he cannot fulfill the function of an attorney. So if he goes out there and says he knows more than an attorney, then obviously the question he'll have to answer is, why exactly did he hire an attorney? Well, Dave, sure. And I'm a first year family law attorney. And I have criticized the firm with 30 plus people and 20 plus years of experience. And I believe I have been pretty accurate with my criticisms. So before you poo poo Michael Me, let's wait and see what he does. Criticize him for his actual law and motion practice and not for his experience. But one thing that I've said consistently over and over again is that I believe that there is settlement value in Decastro's case. And an attorney can get a settlement out of this. Can, potentially. No guarantees. An attorney can get a settlement out of this. And so, in my opinion, it makes sense for Decastro, who cannot negotiate a settlement, to hire an attorney who more likely could negotiate a settlement, to negotiate a settlement. It won't be the big win that Decastro wants. The big win that Decastro wants is not available to him. He's not going to get the win that he thinks he can get. The law doesn't support it. The facts don't support it. But he could get a settlement because there is still nuisance value in this case. So, people are... money is no object. What sandwich do you order right now? A Reuben? Because I love Reubens. Isn't he also his attorney for his criminal charges? Someone said down here that Me is representing Chili in his criminal, well, it's not a suit, it's his criminal case. Is there anything aside from court instructions to ensure juries take beyond a reasonable doubt seriously and not use it more likely than not when determining guilt? Well, there's always the potential of a motion called a JNOV, a judgment. It means judgment notwithstanding the verdict, but it's in Latin, and I don't remember the Latin. You can appeal a jury verdict. That would be a hard one to do. It would be a substantial evidence appeal. But in theory, you could. I mean, all of this would depend on state law. It depends on what court you're in. But JNOV would be your first step. Well, how do you know, Psycho One? He, she, you don't know. You don't know. This could be California, bro. I love to be a fly on the wall. And those, you mean between Decastro and me? Yeah. Well, my heart goes out to Michael Me having someone with as much Dunning-Kruger as Jose has, because Michael Me's gonna be like, okay, this is what we need to do, and Chili's gonna fight him on it, and it's gonna be rough. And I don't know Michael Me's experience in civil. He has set up his firm, and he markets himself as a defendant's attorney for criminal actions. But if this is the guy that I think it is, he advertises like a 100% no incarceration rate or something like that. Basically, he's good at wheeling and dealing in criminal court, is my understanding, and that may #may not translate into being able to wheel and deal in a civil case. So we'll see. We'll see. No, I don't believe in any form of. I don't believe any form of government is effective long term, except for monarchies. Yep. Well, good. Sometimes our own opinions get in the way of things. Philip Turner crap lawsuit against Corgan, Texas, got $45,000. Why was it a crap lawsuit? I think what you're talking about was the lawsuit where Corgan, Texas, put up signs, um, specifically the ones that they would have a real issue with, was they put up signs outside of the police station that said like and where police cars were parked along the side of the road, along the walkway, where they said you couldn't film into the police cars. Um, and like I think their general rule, they had a general prohibition against filming into police cars, and it wasn't narrowly tailored enough. They had a good, yeah, I think he had a good case. I don't know why you think he didn't have a good case. Wait a minute, Surfith. I thought you were pro auditor. Jesus Christ. No. Philip Turner had a the only issues on the Philip Turner case that would have made it not necessarily as good as potentially it could have been was that prior to filing the case, the town of Corrigan had withdrawn uh, that particular ordinance, so it was no longer in effect. So his damages would have been reduced down to like the pain and suffering and the loss of income and things like that from the arrest, because I think he was arrested. I'm pretty sure he was arrested. So he would have gotten some damages from that, but $45,000 is pretty much cost of trial. So basically the city of, or the town of Corrigan, gave him the cost of trial to go away, because there is a good chance that he could have prevailed. I think there's a strong chance he could have prevailed, and it's not 100% guaranteed, but there's a strong chance. And he could have gotten more money by a sympathetic jury for his pain and suffering. So yeah, it was go away money. There could be a directed verdict. Yes, there can be a directed verdict. I'm not sure that you can have a directed verdict in a criminal case, though. Maybe you can. I don't know. I'd have to think about it. Perhaps the judge could order a little go away money, hold the money. I don't know what we're talking about there. Do they teach law students how to negotiate in law school? No, they do not. Uh, Hello, Logan. What we need is a criminal lawyer. Well, maybe a little family law attorney would be able to help out too. None that I'm aware of. And how would you teach someone how to negotiate? That'd be an interesting thought. I think you could only really learn how to negotiate by actually negotiating. Because there's a lot, because you got to read the other side. Well, first of all, you have to be able to value your case, or you have to value the case, and you have to be able to read the other side. And there's a lot of little things that are going into it, like are they on contingency, or are they paying hourly, or what? Why? Why? It should be about justice, Logan. It should always be about justice. You did. Interesting. All these kids nowadays get negotiation classes. Did you negotiate with the teacher about what grade you should get? Yes, it was really worth it in the end, because the trial would have cost $45,000 plus, like $45,000 plus, and the ordinance was already uh, eliminated, removed. So why go to trial on it? Why not just hand him the money? Did John Bryan settle that judge searching a guy's house for a measly? Why did John Bryan settle that judge searching a guy's house? I don't know who these people are, so I couldn't tell you. I couldn't tell you. Was this the family law judge that went to make sure that property division was carried out correctly? Um, I don't know. I don't know what you're talking about. That guy. The injunction may have been worth it. Sure. You say the lawsuit. You say the lawsuit would be thrown out. What? Did I say that, Surfith? Go ahead and find where I said that. Go ahead and find where I said that, Surfith. Go ahead and find it. Put the link in the description, or put the link in here, or say the name of the video or whatever. I will pull it up. You find it. I'll pull it up and we'll play it right here. And you can show me how wrong I am. Right here, we can do it. Well, that's interesting. Well, I know Texas, so I'm not obviously not a Texas law guy, but I know there's different, like there's home rule cities and yada yada. There's Texas draws a lot of distinctions between different cities and towns and things like that. So, and there was also the nifty little problem that weren't they sued in federal court under a federal statute? Wasn't it a 42 USC 1983? Didn't I'm almost positive that they sued Corgan in federal court under a 1983 statute. So Texas's limitations would not limit anything. Texas can't. The U.S. Congress set the bar for a 1983 lawsuit. Yeah, there's no precedent, but there was no precedent to set. Corrigan had already eliminated the ordinance that was at issue. So, what precedent could they set? I'm going to assume that he got at least charged with something, and he's going to go to trial over it, unless he pleads. You believe that's? I believe that's. Oh, I don't know what you're talking about. Directed criminal verdict, that is. Yeah. I mean, there might be a situation somewhere where you can get a directed criminal verdict. Might be. But I'd have to look into it. I don't think they do that for criminal. If there is a way it can be done, it would be a very special set of circumstances. Mock negotiations and a lot of game theory. Yeah, unless you negotiated your grade, then it wasn't worth anything. Judges look down. No, you're fucking retarded, Surfith. You are retarded. Judges don't give a shit about lawyers pushing lawsuits when there's a fair statement offer. And I'm going to tell you why. Because the judge doesn't know what a fair statement offer is. Because a judge doesn't have all the facts in front of him because there hasn't been a trial. And lawyers don't give a shit about anything that you're saying there because a lawyer is going to count his pennies. What's going to get his client the most money? Because normally what gets the client the most money is going to get the attorney the most money. And you got to count in the value of time, money over time. So money now is worth more than money later, and doing more work is going to make the money worth less because you're more work for less money. I mean, you're dumb. You're dumb and you're talking about things you don't know. The civil rights lawyer. Yes. What do you use to make an educated guess and the settlement is go away money, or they are really worried about the uncertainties of going to trial? So the uncertainties of trial are what make people offer go away money. I will guarantee you they think that they can win. I'll guarantee you that because they've already gotten rid of the ordinance. So, well, uncertainty of trial always plays into any settlement negotiation. I'll leave it there. And go away money is go away because I would rather pay you $45,000 certainly than to pay my lawyer $45,000 and maybe have to pay you at the end of trial. That's a fair statement. It's like talking shop. Oh. John Bryan is a civil rights attorney on YouTube. Okay. Is this from some previous comment that I've already forgot? Why did John Bryan settle that judge searching a guy's house for a measly $2,000? Like, well, again, so why did the civil rights attorney settle that judge searching a guy's house for a measly $200,000? I don't know. Maybe because that's what the client accepted. Because the client gets to accept or reject offers. The attorney can make a recommendation to accept it or not accept it. But at the end of the day, if they made an offer for $200,000 to settle the matter and the client said, yes, I accept, it doesn't matter what the civil rights attorney thought or didn't think, because he can't stop his client from accepting the offer. Surely receiving money from the lawsuit will only encourage him to keep harassing police and disrupting traffic stops. Well, Namor, not winning hasn't stopped him. So say what will stop him, Namor? Oh, nothing? But so you think him getting money for doing what he has continued to do despite losing over and over and over again, you think that's going to encourage him to keep doing it? Well, he's still doing it, bro. Like, he hasn't stopped. He's never been discouraged from it. Okay, congratulations. About that judge. Since when does a judge become law enforcement? That would be my question. Well, so that judge, I believe, was sanctioned and is no longer a judge. And yeah, you can't. The judge is supposed to make a ruling based on what the parties present, not to be an active investigator in it. I think in Europe, the judges will take investigatory roles, but no. He got a few felony charges. I don't know who he is, but okay. I love your icon. Okay. Did they post the state response to the Worden appeal yet? No. The Worden appeal, the state got until February 7th. I had a directed criminal verdict of not guilty. Well, yeah, the judge can direct the criminal verdict of not guilty. But the pending question was, is there some way that a judge can make the jury find guilt based on beyond a reasonable doubt and not just on a preponderance of the evidence? So it was your answer. It's a different question that you're directing your response to. Yes, a judge can direct a verdict of not. A judge can find that you're not guilty without it, because that wouldn't violate due process, because you haven't been found guilty and denied your jury trial. You've been found not guilty. What are you gonna do? Say no, I want my jury trial and roll the dice again? That's the difference. Would you represent an 8-time convicted felon running from a felony arrest warrant? Sure. Why wouldn't I? But I don't know who you're talking about. Who's an 8-time convicted felon running from a felony arrest warrant? You're talking about me? So if you're talking about Michael Me, Chile only has a misdemeanor bench warrant. He's not going to get extradited over anything, as you might already be able to tell, because he was arrested in Las Vegas, Nevada, and they didn't extradite him to Ohio. So the only person who cares about this is you and the state of Ohio. And I don't know that, was he convicted 8 times for felonies? I don't think so. I don't know. Why is that addressed to me? I don't know. What's a fair statement offer? No idea. What's a fair settlement offer? Again, the only people who can determine what is or isn't a fair settlement offer are the person proposing it and the person who has the capacity to accept it. The person who could propose it and the person who could accept it. Those are the only 2 people who can determine what a fair settlement offer is. You're stupid, and you should probably stop. The guy claimed several people struck him. I was charged with aggravated battery. The judge ordered not guilty. Congratulations. Jasper, game theory is more complex. I want to learn how to be a better negotiator. In order to be a better negotiator, you have to understand the value of your case or your thing better than the other side does. That's how you do it. If you car salesmen, they know the value of the car better than you, the buyer, does. They know what they paid for it, or how much interest they've paid on it if it's one of the lend lots. So they know how much they haven't sunk into it. They know how much they need to get out of it, yada yada. So because they understand the value of their product better, of what they're selling better, they're in a better position to negotiate than you are walking through the door. And that's how car salesmen and car lots stay in business and make money. Negotiate yaki, mandu, and ramyun at 3 a.m. drunk in the rain. You'll learn something. Okay. Checking your Turner, Wallace, and Decastro filings right now. You go, buddy. You go. I will wait with eager anticipation. I mean, I got an A, so I was happy with my entering position, although it was the last summer class I needed before graduation. I cared more about just passing and prepping for the bar. Do you think there's anything in Chili's case that a proper lawyer can get over the line? You mean win at trial? No, I don't think you could win at trial. But just because you can't win at trial doesn't mean there isn't settlement value. Don't judges want to get cases off their docket, and that's why many courts push? Absolutely. The judges do. They would love to get cases settled. But what Surface was saying, the judge is in a position to value the settlement offer. The judge will push the attorneys to attempt to settle it. That's why. So let's move ahead a little bit, and let's go to Springer. This is the latest filing in Springer. Springer versus the 7th Judicial District Court. There is a settlement conference set. Why is there a settlement conference set? Because it's a mandatory settlement conference. The District of New Mexico Local Rule Civil 16.2a mandates that, except for a few cases, a few specifically identified cases, every case has to go through a settlement conference. It doesn't mean it has to settle, but it means it has to go to a settlement conference. And what does that mean? It means that counsel and parties have to appear in person. And the person who appears in person has to have full and final authority to enter into a binding settlement, i.e., for the plaintiff, it has to be someone who has full and final authority to accept an offer. And from the other side, the defendants, they have to have someone there with full and final authority to recommend an offer or to make an offer. And it doesn't matter if you're out of town or whatever. You got to have someone there with full settlement authority in person. You have 7 calendar days before the conference to ask to be excused from it. So the plaintiffs have to serve a letter setting forth the information that a defense attorney would need to be able to recommend a settlement. So Springer has to send a letter to the defendants on or before Wednesday, February 21st, setting out all of these things, right? And then by February 28th, the defense counsel shall send a letter that basically responds to it. And then they have to meet and confer, and then provide copies of the letters to the I'm sure it's probably a magistrate or a pro tem magistrate who's going to be conducting the settlement conference. And then they have to give the copies of the evidence to the magistrate. And then, so this magistrate is not going to be involved, I don't believe, in the actual case. This magistrate is just going to be handling the settlement. So this will allow, because this magistrate will have an opportunity to see the audio video recordings, then it'll put this magistrate in a better position to make a recommendation. Now, an audio video recording isn't necessarily going to be admissible into evidence. So at trial, the audio recording may not be admissible for various reasons. The video recording may not be admissible for various reasons. but that's not an issue necessarily for this particular situation because this is just a settlement offer. And Merb, that's exactly what the civil rights attorney said in a video. It's up to the client. Yeah, because that's 100%. So I don't know why people are asking me about it. Yep, you are right. Of course I'm right. I'm always right. It's the beauty of being me. Judge, you were offered $200,000, but you pushed it, wasted the court time, so you get $1. No, but there is, in California at least, and probably other states. Oh, I'm out of coffee. Boo. There's what's called a 998 offer. Is it Code of Civil Procedure Section 998? I think it is. But basically what that is you send an offer in writing saying, we are willing to settle the case for this amount of money. Now, there's various caveats and rules about it, but this is just a broad overview. You send this and you say, pursuant to CCP Section 998, this is our offer. And what happens is if the other side doesn't accept that offer and gets a worse result at trial, then the side that rejected the offer but got the worst result may and probably will be responsible for the other side's attorney's fees and expert costs after that offer. So you make the offer, the other side has 30 days to accept. If they don't accept it, and then they get a worse result at trial, from the day the offer expired to trial, those attorney's fees that you incurred, the other side will probably have to pay for. Probably. And any expert fees, the other side will probably have to pay for. That doesn't, the court isn't going to just say you get $1 instead of the amount of money that the jury awarded you. So no, it doesn't work quite the way you think it does, but there's something similar to that exists, if that helps. Why do they keep granting extra time? Because attorneys are busy. And you might think that that a month is plenty of time, but if you have like 20 other cases going on and you're in trial for, half the month and preparing for trial the other half, I mean, time gets away from you. Also, wouldn't there be situations where the plaintiff's attorney realizes they've gotten in way over the head dealing with the severance defendant but doesn't want to screw their client? I don't know what you mean by way over their head. If the plaintiff's attorney took it on contingency, they got to do the work. I mean, you can't just be like, client, you have to accept this deal because I can't keep up with all the wallpapering that the defendant's attorneys are doing to me. Okay, peanuts. Okay, talking about Jimmy Coy Hag, CJ Chickenhawk is supposedly his attorney. Well, there's the old I don't know, common sense, folksy wisdom that an attorney who represents himself as a fool for a client. I don't know how well CJ does or does not represent clients. There was that one incident where he went in on a motion to get a client's gun back. The judge said no for whatever reason. I mean, this is all CJ's telling of it. And CJ was going to sue the judge before I laughed at him and mocked him and pointed out that you can't, you idiot. So that particular case might be an outlier. I haven't seen any of CJ's actual practice of law. He may know more about the Second Amendment than I do. He may know more about he definitely knows more about Texas gun laws than I do. He might be able to do good things, right? So, yeah. In regards to Chili's new attorney, you overlook the fact that Chili is a know-it-all and will try to control how his attorney handles the cases. Well, gee, Jay, if I hadn't actually talked about that very fucking specific situation, you might have a point. But since I did talk about that very specific situation, you look fucking retarded and your shit's all fucked up. So, there are provisions where if you're offered a settlement and win a lower amount, you can be liable to defendant's attorney's fee. FRCP 68. Yeah. Offer of settlement, yep. Or offer of judgment. Good evening to you, Vlad. Ha ha ha, Murby's. Every time you say Springer, I hear Jerry, Jerry, Jerry. Yeah. Well, he does kind of function like that. Logan Sandman, me too. Oh boy. 3:45 p.m. and the family attorney is chilling making videos. Uppity bastard. Yes, well, this uppity bastard worked on MLK Day. All right. So because I put in my time and I spread out my work over a couple days, and who worked this weekend? Yeah? Were you working this weekend? All right. Didn't think so. I work settlements every day. You're right. Okay. You would know better from the following case, but is Springer going for a win on his A1 rights or a settlement? Well, I think that Springer's going for a win on his First Amendment rights. Yes. I think his attorney is very confused about what substantive due process is, what procedural due process is, and what First Amendment rights Springer had. But the only money that they could make is from the Seventh Judicial District Court itself, i.e., the state of Arizona, and how much money they can get from that court, I don't know. So they sued all the judges in their individual capacities, but they're only seeking equitable relief from them, injunctive relief. What would motivate a state agency who is not the prevailing party in a court arbitration to request a trial de novo rather than just pay the award of $10,000? There's a lot of I mean, it would depend on the specific facts of the case. They might be just trying to prove a point. I don't know. There are other considerations other than just the cost of trial. So I don't know. I don't know. Oop. Wouldn't settlement conferences be where the judge might start to get annoyed? Well, might. I mean, if the judge finds that one party or the other isn't negotiating in good faith, but generally speaking, the trial judge will not be a part of that. At least not in California, and apparently not in the District of New Mexico. It's not the trial judge that takes part of it. So there's mandatory settlement conferences in California before trials, and you go in front of like a judge pro tem or a judge that's not part of the case who just deals with settlement, so it doesn't taint the trial. Your video, Turner, Wallace, and Decastro filing. I don't see how the police are liable where there was an ordinance that was not found unconstitutional. 12:45. Well, let's look it up. And that's different from saying they won't win, but we'll look it up. We'll see. Well, I know I have headphones, so I don't know if this is going to. I mean, it might blow everybody's eardrums out, but we're going to try it. An ordinance that had not been found to be unconstitutional, and the police were enforcing that ordinance. I don't know how the police are going to be liable. So it will be interesting. And if he does prevail, then great. And if he does prevail, then great. Huh. That's where I said he wasn't going to win, huh? That's where I said he had a bad case. Me saying that I don't know how they'll be found liable doesn't say that they can't be or won't be. You read into these things what you want to hear there, Surfith. Unfortunately for you. Okay. Merb worked on MLK Day, and he can sit at home with the Roosters fish if he wants to. Damn straight, Vlad. You're welcome. Per diem judge? Pro tem. Pro tem means like for the day. pro tem means like for the day. No matter who Chili hires for his attorney, he doesn't have it in him to let someone else. Well, how do you know this, Jay? Do you just jerk off thinking about how Chili is going to wreck his own case? Let him figure it out on his own, man. Oof. Well, hello. All right, so we're caught up. Did you see the Gilead decision by Cal Appeals Court saying are liable for failure to innovate? I have not. I don't know. I'd have to look it up. I don't just sit around reading Court of Appeals cases, believe it or not. All right, so we're moving on. Moving on. So this is Decastro's Court of Appeals brief for the Sixth Circuit. This is out of his Decastro versus Wagner et al. So one, did the court incorrectly decide the facts? This is his pro se appellant's brief. It's supposed to be very simple. You're not supposed to like make complicated arguments. This is basically, you're going to try to give the court an idea of how you're going to give the Court of Appeals an idea of how the district court effed up. So he said, yes, the court incorrectly decided the facts. If so, what facts? Number one, the court finds that, quote, a city employee announced the building was closing and would be locked, end quote. Okay. As to intent, I did not know it at the time if this was an employee, and the video, which was also submitted, establishes this. So the video establishes that he didn't know that the city employee was a city employee when the city employee announced that the building was closing. Because obviously, if someone says the building's closing, it could be a random person, right? Normally, you expect random people to announce that the building is closing. The amended complaint is based off of limited discovery where the city had alleged it was an employee, continued on attachment 1, and then we go down to attachment 1. The allegation that it was a city employee is a conclusory statement. It's not a conclusory statement. Saying I work for Jack in the Box is not a conclusory statement. You're saying a fact. The fact is that you work for Jack in the Box. A conclusory statement is like, I was assaulted. That's a conclusory statement. You're not saying what physically happened to you. I was hit. You're saying the legal conclusion of I was assaulted. Saying that it's a city employee is a statement of fact. There is some sort of an employment agreement between the employee and the city. Ergo, it's a city employee. And the city isn't contesting that it was an employee, and the employee isn't contesting that they're an employee. So it's, like, for example, if the subject matter was like an employment lawsuit where the city is saying, oh, this is an independent contractor, and the alleged employee is saying, no, I was an employee of the city. Well, then it would be a conclusory statement because that's at issue. But this isn't at issue. So it's not, in this instance, it's not a conclusory statement. It may later be proven to be an employee as to the fact that the person might have had the authority to withdraw privilege. It might later be proven to be an employee as to the fact that the person might have had the authority to withdraw privilege. What the fuck does that statement mean? It may later be proven to be an employee as to the fact that the person might have had the authority to withdraw privilege. Yeah. New tab. Ohio revised code, criminal trespass section. Ohio revised code. All right. So this statement right here is what I think he's thinking has to deal with. But I think it is this statement right here that's the issue. So 4 says, being on the land or premise, it's no person without privilege shall be on the land or premises of another, negligently fail or refuse to leave upon being notified by signage posted in a conspicuous place, or otherwise being notified to do so by the owner or occupant or the agent or servant of either. However, it's just so simple that if you don't have privilege, you can't knowingly enter or remain on the land. So did he know that it was closed? Sure. Because someone said it. So I don't think anybody had to remove the privilege, although it could theoretically be this one, because this is just negligence. What was he convicted of? Anybody remember? You said it's a good case and then described a bad one. Oh, Tim. Yeah, but so he didn't the privilege of access ended. He didn't remove it. It ended when the building closed. The employee didn't remove it. The employee gave him the knowledge that the building was closed. But I guess Chile had to look at the atomic clocks or something from YouTube. Assuming a person has a good 1983 case but can't find an attorney because the damages are low or something, what's the number one thing you'd recommend not doing that these auditors do aside from going pro se? Well, if you have a good 1983 case, well, so there are some instances where you can't sue for money and you have to sue for injunctive relief, like if you're suing a judge. If you're suing a judge, though, for something they've done in their official capacity as a judge, not as in an administrative capacity, then you probably already done fucked up. It's almost never a good idea to sue a judge. The number of circumstances wherein it is a good idea to sue a judge are very low. But assuming that this is one of those cases where you have a good 1983 case, but can't find an attorney because the damages are low or something, you mean, well, the number one thing I'd recommend not doing is going pro se. The number one thing I'd recommend doing is paying an hourly rate to the attorney. There are provisions for attorney's fees. You could also go to, like, a lot of law schools will have clinics or things like that where they'll have pro se parties. They can get help from the law students who could do limited practice under the eye of their teacher. There's also like in Nevada, there was that Southern Nevada Law Center where they would do pro bono stuff for people with good cases. So if you had a good case, then like what Chile tried to do for Turner, where one of the things the court will do is look at, is this a good case? Do you have a good odds of winning? Are you a indigent and do you have good odds of winning? And then they'll recommend you to that clinic. So it's kind of context based, where, like, depends on where you are and what resources are available. But for a real world context, if Wallace had a good case, then the court would have likely recommended him to the pro bono counsel, I guess, is what I'm trying to say. It means they might have the authority to close early. Is contesting the whole atomic clock thing. Remember that they were technically open. Yeah. Well, I don't think most companies, most stores, most public buildings closed closed based on atomic clocks. So I don't think that's really a good. Why should who get a dime? Failure to appear, trespassing. Maybe name new dog Glock. 100%. I'm just trying to interpret stupid. I think he's talking about employee privilege. Did the employee have privilege to kick him out? Well, the employee didn't kick him out. The cops arrested him. No one kicked him out. He knowingly entered or remained on the premises of another after it was closed. So I don't know what that's what I'm going with. And you can tell me how wrong I am. As to whether the signified plaintiff intent to trespass when plaintiff thought it was a fellow protester passing on information is a question of fact which a reasonable juror could find for the plaintiff. Well, either way, so if it was a fellow protester who said, hey, building's closed, well, that doesn't really help you because that puts you on notice that the building's closed. And I have to go. We maybe pick this up another time. Thanks for watching. Have a great day.